The judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
May be seated. Eric. Rissick. I was informed and still did it back poorly. Mr. Rissick, excuse me. You may come up.
Thank you. Good morning, Your Honors. Chief Judge Gregory, Judge Wynn, Judge Floyd. My name is Richard Rissick, and I mean no offense, Your Honor. It's mispronunciation. I'm used to it. So I'm honored to represent the family of Calvin Witherspoon, who suffered a carbon monoxide poisoning death due to the deliberate indifference of the Columbia Housing Authority. The decision of the district court dismissing my complaint for failure to state claims under 42 U.S.C. 1983 must be reversed for two reasons. One, the district court ignored the Iqbal standard of plausibility and the litany of detailed facts that were pled, and instead made its own factual and causation determinations. And two, the district court erred by requiring an allegation that the housing authority had actual knowledge of a prior poisoning or exposure had to be made in order to establish deliberate indifference. That holding is not in any 1983 jurisprudence, and that is contrary to Chief Judge Gregory, your recent opinion in Dean versus McKinney, where we talked about the spectrum of liability.
Well, I have a little problem with the how the court interpreted the phrase "almost bound to happen sooner or later." How is that different from likely to happen in the long run?
Your Honor, that's a factual determination. In 1983 cases, we look at proximate cause. And especially at a pleading stage, all I have to establish is plausibility. Are these things plausibly related to the violations and deliberate indifference posed?
So those words are not magical words, regardless of which one you used.
Your Honor, I would agree. They are, because the traditional analysis of causation under 1983 is still proximate cause. It's going to be up to the jury to find that connection, just as they do as we ask them to make all kinds of factual determinations, that in fact, these violations were the proximate cause of the death of Calvin Witherspoon. Your Honors, carbon monoxide is ultra lethal, and I think that's what makes this case so incredibly unique. It is known as the silent killer. It is undetectable by humans. It is odorless. It is colorless. It is tasteless. And your first exposure will often be your very last. No human can detect it, and the only way it can be is with a carbon monoxide alarm. The first symptoms of even being exposed to carbon monoxide are like the flu, fatigue, malaise. You wouldn't know to even connect those general feelings of ill with carbon monoxide poisoning. And the housing authority recognized the ultra lethality of carbon monoxide in their own policy.
So you bring this as a Monell claim.
Yes, I do, Your Honor.
And you contend both that the city violated official and unofficial policies.
Correct, Your Honor.
From the perspective of the district court, which went the other way, how do you say the district court erred?
Your Honor, the district court erred because in recognizing and in the pleading standard of deliberate indifference. And you're right, what I asserted was two direct Monell claims, one for the official policy that I was just about to get to, which was policy 8.1.c, which I think is really critical to the analysis. And in fact, Your Honor, was ignored entirely by the district court in their opinion. In 2017, the housing authority themselves recognized carbon monoxide as quote unquote life-threatening. They passed policy 8.1.c defining life-threatening conditions and said the following. The following are considered life-threatening condition: missing or inoperable carbon monoxide alarms and improper discharge or venting of carbon monoxide gases. Staggeringly, Your Honors, in passing that policy.
So the first question deals with whether there's a constitutional violation.
Correct, Your Honor.
And the district court basically says no. The 14th Amendment
right to bodily injury does not exist here. You all seem to agree, at least insofar as the indifference standard, the deliberate indifference standard, but you disagree in terms of the level of proof that's necessary for it. So there's the conundrum we face first in determining what is the level of proof that's necessary for deliberate indifference.
Correct, Your Honor. And what I would say is there isn't one standard of a level of proof for deliberate indifference. As the opinion of Dean versus McKinney talks about, referencing Sacramento versus Lewis, what we are talking about is a culpability spectrum.
Do you require actual knowledge?
Did they require actual knowledge? They required, and I want to quote because I want to make sure that I say it correctly when you say actual knowledge. What is required? A state actor's actions demonstrate deliberate indifference where the evidence shows the actor subjectively recognized a substantial risk of harm and his actions were inappropriate. You know, in McKinney, we didn't require Officer McKinney to previously cause a crash. We didn't have to say, Officer McKinney, you get a one free crash rule. Because unless and until you know driving 83 miles an hour on a country road without your lights on and you kill someone, you can't commit a constitutional law violation. Because what this court recognized and what the Supreme Court recognized in Sacramento versus Lewis is that we have to look at factors. We have
The
to
big
look
question is what brings this from negligence to deliberate indifference?
Your Honor, I would, first of all, with the subjective knowledge of the harm, when the housing authority says what we are dealing with is life-threatening and requires to be corrected within 24 hours because it's so life-threatening, we are dealing with something that they know itself is ultra lethal.
In other words, you're saying this risk of harm is so obvious, they ought to know about it? Is that
Well, they do know about it. They subjectively know about it because they passed this policy. And even further in this policy, Your Honor, to show
how do they know about it?
Oh, without a doubt.
I understand that's without a doubt does not answer my question. You understand that, don't you? How did they know about it?
Your
That's
Honor,
not a fact. How without a doubt is what I'm saying.
by passing a policy that required tenants who lived in private properties and their homeowners, they defined a missing carbon monoxide detector and improper venting as life-threatening themselves. Now, they exempted themselves from this own policy. They
That's creating a risk of harm that you say is obvious.
Absolutely, Your Honor. Because when you couple it with the other things, which is they were legally required by both the state and the city to install carbon monoxide alarms in these apartments. They did not do so. They never tested for carbon monoxide poison. So they knowingly and willfully violated the law of the state and the city. Keep in mind, Your Honor, this is a housing authority. This is their business. This is what they exist for. Their charter exists to provide housing. They are mandated by their charter. They are mandated by state law. They're even mandated by the lease. They promise tenants.
So they say it's mere negligence, though, because they weren't aware of any carbon monoxide emissions before Mr. Witherspoon's death.
Your Honor, if you refuse to look, you refuse to test, and it's humanly undetectable, that's exactly what makes it so dangerous. And to give them a pass because they were legally obligated to detect it, you know, an alarm does two things, Your Honor. It first of all, it gives fair warning to the person who's in the room that, hey, you are about to be poisoned. And number two, it lets the world know that something's producing this horribly ultra lethal poison.
Don't you need to show some type of prior evidence that, you know, something like this can occur? I mean, is it speculative to say, well, you didn't put the carbon monoxide poison in and therefore there's a risk of harm?
Your Honor, when you keep adding up each one of these elements, when you have 30-year-old furnaces in small enclosed places where people sleep, where you don't take care of them, where you don't maintain them, you don't put the alarms in place that will test and give people the opportunity to not be poisoned, when you are required by law, when you recognize that that exact harm is life-threatening, when you keep piling each one of these factors, and then further that their unlawfulness, this wasn't a quick change in the law. This wasn't carbon monoxide alarms were required to be installed in the next day. This wasn't the battery failed in the detector.
Well, let me ask you this. Are we here at the pleading stage?
Yes, Your Honor.
So there's a good bit of reliance in your in the briefings on the Carter case and the Dean case, my recollection is that those cases were decided at the summary judgment stage.
Correct, Your Honor. I have not even had the opportunity for discovery, and I've pled all of these detailed facts establishing. You know, my colleague and friend, Mr. Turner, is going to be back up here, I'm sure, or back in the trial court on summary judgment if I'm not held to this standard of proof. But I believe these facts more than establish plausibility and establish a question of fact as to whether or not the Columbia Housing Authority was deliberately indifferent.
Well, even if you get that, you get the deliberate indifference to as a substantive due process right, you still have to come forth and show that this conduct is attributable to some policy or custom that provides, and that's a separate inquiry.
Correct, Your Honor. And that's the policy that I was absolutely referring to, was policy 8.1.c, where they said carbon monoxide alarms are required to be installed and maintained. Vending must be maintained. If it is not, and it is not corrected in 24 hours, that is a life-threatening condition. They passed that policy, and they made that policy applicable to private homeowners who rent to tenants who qualify under HUD guidelines, but also made a second policy choice. They exempted themselves. The custom in this case, Your Honor, also too goes back to something that is pled in great detail. The housing authority pursues an unofficial policy of neglect of its properties. That's what it does. Saxon Homes, Gonzalez Gardens, Henley Homes. This is what they do. And what they do is they allow these properties to get into a state of absolute disrepair as a matter of policy, because the motivation for that is then you can apply for HOPE grants and have them demolished.
Is that policy official or unofficial?
That's unofficial, Your Honor, and that's exactly why it was the second cause of action. It was an indirect Manel action. And if you look, I went through and showed you this is exactly what they do. They neglect the property, allow it to fall into state of repair, property gets condemned. In the meantime, they're applying and filing for HOPE grants and say, hey, we need to demolish these properties because they're so terrible. So people are living, and they know, in a state of disrepair, and it creates a further financial incentive for them not to do maintenance. You know, following the death of Calvin Witherspoon, Your Honors, 869 code violations were found by the fire chief of the city of Columbia. These are not experts. These are not my hired guns. This shows you the level of decrepitness and depravity of the people who are managing these properties, that these people were living in such horribly dangerous and unsafe conditions.
And that can be the basis for establishing an unofficial policy?
I believe it can, Your Honor, because what it says is that, again, we're back to arguing the proximate cause. Your Honor, if I don't take care of my furnaces and I know they produce carbon monoxide, and I don't put alarms in place, and I don't maintain them, and then someone dies from carbon monoxide poisoning, I can't say, I'm surprised that someone died from carbon monoxide poisoning. No, it's a natural and proximate result. That's the essence of proximate cause, especially when we ask where the burden is slight, in this case, $5 for a carbon monoxide alarm, for people who are in the business of providing housing. And I would also add, in terms of looking at factors, you know, at Dean, when we said, you could say Dean was just a car wreck case. That's what it was. But you know what? When you added up all the factors, we have deliberation. Here, we have a board of commissioners who manage millions of dollars, who exist solely to provide housing. They deliberated over all of these decisions over the policy of 8.1c for 2 years prior to the death of Calvin Witherspoon. They mismanaged these properties so badly, these were actual statements. The executive director said he had no idea what the code laws were. Can you imagine? Can you imagine a housing authority in the business of providing housing where the executive director says, I have no idea what the code laws were?
You threw me off when you said Dean was just a car wreck case. That wasn't what Dean was. I mean, it was a car wreck, but that wasn't what Dean was dealing with. It was dealing with a police officer who had been in a situation of speeding, questioning what had to do. How's the liability attached to that?
Correct. And this court found there is liability that attached to that because it was a substantive due process violation given the egregiousness of Officer McKinney's actions. He was driving 83 and a 55 on a curved road. He didn't have his emergency lights on. He was not responding to an exigency. He had time to deliberate and conform his conduct. He knew what he was doing was unlawful because he was not allowed and was not privileged to speed by South Carolina law. All of those things added up, and by keeping his lights off, he made the danger greater to the public. Adding up all those factors, this court said in that opinion, that creates a question of fact.
Well, your opposing counsel says in his brief that in that case, the Dean case, that officer, he had a lot of prior stuff against him. I mean, it wasn't the first time it happened. That was significant in that decision.
Your Honor, it wasn't that he had prior stuff. He had, in terms of his training, he knew the dangers of speeding. He knew the dangers of driving without his lights on. Here, the Columbia Housing Authority, and I see my time is up, Your Honor.
You may finish your answer.
Thank you, Your Honor. Here, the Columbia Housing Authority themselves, and we talk about subjective knowledge of the risk of harm. When they say this harm is life-threatening, we can take them at their word. They put it in their official policy and then cravenly exempted themselves from that policy. Thank you, Your Honors.
Thank you, Mr. Rizek. Mr. Turner?
May it please the court, Your Honor. Beginning with the standard of review that opposing counsel provided to the court, we of course agree with the Iqbal and Twombly standard of plausibility, and I think plausibility requires more than just bald allegations. I think plausibility requires some type of level of allegation, some type of level, not evidence in the complaint, but some type of allegation that would show the court that the issues and the standards in this case, that is, did the CHA, the Columbia Housing Authority, know facts from which it could, infer that a substantial risk of serious harm to Mr. Witherspoon existed as a result of carbon monoxide being emitted by its furnace.
Did it have to have actual knowledge?
Your Honor, there has to be some level of knowledge,
Is it
actual or constructive. And I want to parlay that question into the Dean case, and Your Honor is correct. The Dean case provided a plethora of facts and allegations in that case regarding prior instances with Officer McKinney, prior remedial training, prior knowledge by McKinney, as well as perhaps the Anderson County Sheriff's Office, that he posed by his habits, by his custom of driving, posed a threat.
It wasn't his customs. I wrote Dean, so I may know a little bit about it. It wasn't his customs what he did on prior times. It was what he did that night. It was not an exigency. He was driving 80 plus miles an hour, curvy road without lights. And the risk was such that it posed a proper standard under the law to go forward. I mean, every fact in the case is not the one that's dispositive. Yes, he did have there was a record there, but the key was what he did that night. That is what the driving force of it was. And if that's your argument of distinction is, go ahead. Any others?
No,
Okay.
I'd like to add on to that. That night, he had been called off of a code response by his supervisor.
That's right. That night. That's what I said. What he did that night, or what he didn't do that night. But you suggest as if it was his prior record is what was the salient facts that led to the conclusion, and that's not correct. But go ahead.
Well, we're here on a motion to dismiss, which is pleadings. Tell me, we're not talking about proving up anything right now. We're just talking about words. What did he not plead that would entitle you to a motion to dismiss?
He did not plead sufficient allegations of knowledge on behalf of the Columbia Housing Authority that would show or prove a substantial risk of harm, substantial risk of serious harm to Mr. Witherspoon. He did not plead that there was any type of prior notice of problems with the furnace at issue in the unit. He did not plead any prior problems with furnaces throughout the apartment complex. He did not plead any prior citation by the Columbia Fire Department or HUD, who, by the way, had just inspected the properties within a year and a half of the tragic event occurring.
Well, what about the policy that the state and the city had about carbon monoxide detectors, they were aware of that and did nothing.
Yes, so that was the change in the fire code that occurred several years before this event.
Right.
The code and the fire code is different than the International Property Maintenance Code or the building code.
Well, are you saying they don't have to pay attention to all the codes?
No, sir, I'm not saying that. What I'm saying is there was a change in the code, but there was no notice given by the fire department in Columbia, which, by the way, was directly across the street from Allen Benedict Court, that they needed to put in the fire alarms to satisfy with the code. There was inspections done. There was never any notice given, and I know I know what Mr. Rissick would say to that. Well, it's your responsibility to know that. But this gets to the heart of.
Would that be wrong if that was the response? That is your responsibility to know.
Negligence case. But in a 1983 deliberate indifference case, I do think it makes a difference because there has to be a higher standard of culpability on the culpability spectrum, as the Supreme Court noted in Lewis versus Sacramento, and this court noted in Dean versus McKinney.
Right.
So how do we get to knowledge? Is it actual knowledge? Is it constructive knowledge? I don't know, but there's no allegation of knowledge requisite to substantiate a substantial risk of harm claim.
But there is an allegation of willful blindness. And when you look at the determination of whether the city had actual knowledge, the question is, how can you have actual knowledge if you are willfully blinded? And basically, the opposing counsel cites as an example, says, well, you did not inspect this furnace. You did not install carbon monoxide detectors. You made no effort to, knowing the risk when you have this kind of a potential hazard that can occur, and yet they knew that you would need to put in carbon monoxide detectors and others. And the question that at least in terms of allegations, we're not trying your case for you. You understand that now? We're not arguing as to what a jury would find on it one way or the other. I'm dealing with the allegations. He says it was willful blindness. And if you have willful blindness, can that not be equated to some measure of a deliberate indifference?
Knowing that something could happen, as Judge Anderson noted in his order, knowing that something could happen doesn't necessarily mean it is certain to happen.
That is true. But if you know it could happen and you know there's something you can do to prevent it from happening, and you choose to do nothing or to be blind to it, is that not sufficient to at least create the allegation that would be sufficient to at least get over that threshold of deliberate indifference?
I would say not, Your Honor. I would say that it would require something more, some type of better knowledge. For the plaintiff's case to succeed, Your Honor, a metaphysical certainty of fact has to occur, that 30-year-old furnaces are absolutely certain, almost bound to throw off carbon monoxide at some point.
Is that not a discovery matter? You can determine. I mean, once you get your allegations, it seems like that might be something that then we'd be back on a summary judgment.
Yes, sir, but they don't make any allegation of any prior requisite knowledge, constructive or actual, about the furnaces at issue.
Let me ask you, maybe I just read this in another case. One of my friends in court said, we read a lot of cases, so don't hold me to this. But did the city install them in some houses and not others? The carbon monoxide, so no, they just didn't do it across the board.
No, sir. What happened was, in order for there to be proper HUD reimbursement for rental properties outside the Columbia Housing Authority owned properties, in other words, reimbursement to private landowners or apartment owners, that those apartments outside the CHA has to have carbon monoxide detectors. That's the 8.1.c regulation that opposing counsel is referring to.
Counsel, you said that if they would have to show, for example, I think you said exactly, I'll paraphrase, but it's close to it, that they could show that a 30-year-old furnace will automatically emit carbon monoxide at some point, then there would be something sufficient, correct? You said that?
Yes, sir.
Well, if that's the case, wouldn't you still be able to respond as you are now? We didn't actually know that. Nobody on our staff was a mechanical engineering. Wouldn't you have the same? Couldn't you have the same response? Oh my goodness, I didn't know that. Would that be appropriate?
No, sir. My distinct.
But why not? Why not? Stay right there. You admit that that would not be appropriate for you to respond. I didn't know it. Why not?
Because of the metaphysical fact in my hypothetical that a
No, it's my hypothetical. Oh, that was your hypothetical. Okay, go ahead.
that hypothetically speaking,
Mhm.
that a 30-year-old furnace is certain to throw off carbon monoxide. The certainty of that hypothesis is what would imply the requisite knowledge to me to install carbon monoxide detector.
But at this point, it would just be a pleading. It would be an allegation,
But
right? That's right. It'd just be an allegation, correct?
Yes, sir.
We're not at summary judgment. That's the allegation. You're saying that would be enough to get through it because then you could assume that you knew that or imply you knew that. That would be enough.
The district court noted that the fact that something could occur in the future, 30-year-old furnaces can throw off carbon monoxide.
Would you agree that by inspecting the furnace, you might be able to determine that a 30-year-old furnace is emitting carbon monoxide? Would you agree that an inspection might show that?
It might show that.
And so if the allegation is you did not inspect, why would that not be sufficient to say willful blindness? And therefore, had you inspected, which you say, if you have knowledge of it, then you would know that there is a danger here. You would install those carbon monoxide detectors.
First of all, there was I understand it was alleged to be insufficient, but there was a maintenance program at the CHA. I understand that.
We're only dealing with allegations here, which we take at this point in light most favorable to the moving party,
Yes.
not in terms of whether there's evidence that would refute them. So we're trying to get over the allegation stage. So we will take that at face value that the allegation is you did not inspect.
We did not inspect, and that is a great negligence claim, Your Honor. I do not think.
Why is it not more? Negligence is one thing, but when you you didn't inspect and maybe they would choke them or maybe it would be an inconvenience, wouldn't smell good, but this is something that will kill you. And if you do not inspect, and you just said if they knew knowledge that it would be there at a 30-year-old furnace, which you could find by an inspection, the allegation is you didn't inspect. And therefore, as a result of that, there was no indication of a carbon monoxide detector or anything else in the place. We're at the allegation stage again. I bring that up because we start out with this Iqbal promise thing. We don't really need to go there. We got enough just to deal with 1983 to do that. But that seems to be enough.
Your Honor,
does it not? I don't want to prejudge the case. Let's discuss it.
I would ask Your Honor to consider the case of the city of Oklahoma City versus Tuttle, which we cited in our brief and is cited in the Spell versus McDaniel case. And what that case stood for.
That a Supreme Court case?
Yes, sir.
When was that case?
I believe it was in the 80s, Your Honor.
All right, go ahead and talk.
That case, as cited in the Spell versus McDaniel case, indicates that when you're dealing with a facially constitutional policy, which is what we have here, a facially constitutional policy, then one single incident is sufficient enough to prove causation, the relation of the incident to the policy. When you have a facially, on its face, a constitutionally compliant policy, or in this case, a custom, then more widespread evidence, more evidence of events occurring are needed to raise to that culpability level.
In other words, if you have a facially constitutional policy, then you get one death before you proceed to being liability. In other words, something has to happen before you have it. Is that what you're saying?
No, sir. I disagree with that statement as it was posed by opposing counsel.
Well, I only make it, the death is extreme. You say, if it's facially constitutional, something has to have happened. You are saying something has to happen. In other words, a bad has to happen in the face of that, even though, as you've indicated, constitutional policy or not, an inspection would reveal potentially that the problem exists and therefore you can address it, but to not inspect, as is alleged, and I'm only dealing with allegations. Again, I'm not trying to say this is going to be the way it is, but to not inspect means you just don't want to inspect. Why would you inspect? I mean, if that's the case, what city would ever inspect? You would simply just put in a plant and you just let it go. You would never inspect it. You wouldn't think about putting a carbon monoxide detector on it or anything of that nature. If you do, then you got to address, well, was the inspection sufficient or did you do questions of the carbon monoxide? But under your theory, if it's facially constitutional, then just don't inspect, don't do a thing in the world, be willfully blind. And at the end of the day, if one incident happened, it's mere negligence. Next one, you got a problem.
Well, again, the issue about inspections, there were inspections by the fire department and by HUD.
Again, we're dealing with allegations, aren't we? And we're dealing with it from the perspective of we look at the allegations based upon what the plaintiff's perspective and the light there. I get it. There may be evidence going back and forth. You got that in summary judgment. You got discovery. We're dealing with allegations of the pleading.
Right. And in this case, there's no allegation of prior complaints. There's no allegation of prior problems with the furnace at issue or with any of the furnaces.
And that's a given. And that we accept. No allegation. The problem, as I'm trying to get to, is essentially to go there says you have to wait until something bad goes wrong before you can bring a matter. And when that bad goes wrong, that first person didn't get recovered. It's the next one when you don't do nothing after the first one. Even though you know there's a risk, even though the potential you put in this carbon monoxide emitting type device here, it would detect it. And even though if you just inspect, you might find out. You got people living in these places. And by the way, I've seen these, I should say, when I was in the Navy 7 years ago, a horrific case, just like what you're describing. Oh, you don't have a clue this is going on. There's a reason the detector is in there. This thing shows up and you get like cold symptoms and you have no clue what's wrong with you. And the only way you can know is through that carbon monoxide detector. Am I wrong on that? I mean, when this thing, you can't really smell this stuff. You don't.
And I will say that there were multiple people that lived in the unit that did not die. I don't demean the tragic nature.
Did they get sick?
They some at varying different levels.
Multiple people before or after this incident were they getting sick?
No, sir, because they evacuated the property.
But you said multiple people. You brought this up. I didn't ask this. I'm just asking. Multiple people were in this apartment. Some got sick.
Some didn't get sick at all.
But I want to know about the ones that got sick.
And some unfortunately.
Before he died or not after
No,
that?
it's in the event, the event that gave rise to Mr.
What do you think would have happened had you inspected this furnace? You may have, those people probably wouldn't have got sick, but you wouldn't have had that either.
Well, I don't know. It depends on when the furnace began emitting the gas, the odorless, the carbon monoxide
But
gas.
the key being, it didn't just affect Mr. Witherson's place. It affected a whole area.
It's one unit, Your Honor, with 6 apartments in the unit.
Well, it affected 6 apartments. This one unit, for which if you had inspected it, you would have known potentially. Essentially, you could have had 6 all people in every apartment die. Really, I mean, that's really the outcome of this, is that everybody in those apartments could have died. They didn't, thankfully. You had only one. He's the bad incident, which tells you if you didn't do anything after his, which you did do, then you say the others could then bring an action. We're only dealing at the allegation stage. Again, I keep bringing that up because you guys started out with this Iqbal Trombley thing. And at that stage in the game, it does seem like, at least, and we've only dealt with the substantive due process aspect of it. You really hadn't had a chance to get into the custom and the official policy. That's a substantial issue in the case too, as to whether there's a customer policy.
It is, and the customer policy that they attempt to cite to in the complaint are not facially unconstitutional, which again, I think requires a higher level of culpability and allegations at this stage regarding fault. The complaint itself, and I've mentioned this before, and Your Honor has acknowledged it, is devoid of any type of allegation of prior notice. And I don't want to get back into the whole willful neglect thing. I agree that this is a very good negligence case, which is why the state law claims were resolved.
Well, Mr. Turner, at page 28 of the JA, there's an allegation made, requests for repairs and maintenance, especially as to anything related to the gas furnaces and venting, were not promptly and fully investigated and repaired. I mean, didn't he say that?
But Your Honor, I read that, and I think we discussed that at the hearing with Judge Anderson, that is an allegation as to generally at the apartment complex, not with regards to the furnace at issue. That was in J1. That was the unit where the furnace was located. Not Mr. Witherspoon's unit, but another unit in the total complex.
And you're saying that excludes the furnace, this general complaints about problems?
I think it was conceded at the hearing that there was no evidence of prior complaints about this particular.
What about if you'd had complaints about the other furnaces? Would that have been of some relevance? You got all these different units. You got a separate unit right next to it. Got a big problem. Well, you got that here. I mean, now if you had this instance, if you got another set of apartments over here that happens, you then going to be saying, well, there are no complaints about that particular furnace here.
Yes, sir. And my response to that would be problems with a furnace and working on a furnace may be a whole lot different than inspecting a furnace and trying to determine if it is throwing off carbon monoxide. It goes to the quality of the complaint, the nature of the complaint, what work was done. And there's no allegation in the plaintiff's complaint that there were any issues with carbon monoxide or coming from furnaces in this unit or any other unit at Columbia Housing. I'm well over my time.
Thank you, Mr. Turner. Appreciate it.
Thank you, John.
Busy.
Thank you, Your Honors. And thank you, Judge Floyd. That's exactly the allegation that I'm referring to. And again, at the pleading stage, Mr. Turner wants me to say that somehow I magically knew everything that happened with this furnace in the time frame beforehand, when pleading that exact fact, I believe, covers it. Number two,
he says you conceded it below.
I did absolutely not, Your Honor. There was no concession that they didn't. All I have pled, because I am at the pleading stage, I have not conducted discovery. I have not taken depositions. I can't say what they did or didn't know. What I can say is this, though, is exactly what I said. And where I got that allegation from, Your Honor, and why it's so critical, you don't have to take my word for it. I'd like you to read from my own complaint. Columbia Police Chief Skip Holbrook and Fire Chief Aubrey Jenkins investigated following the death of Calvin Witherspoon and made the following findings. They determined it was caused by a faulty furnace that caused carbon monoxide to build up in his apartment. The furnace that caused his death was 30 years old, and a buildup of debris caused a carbon monoxide vent to stop working. The investigation found no preventative maintenance was done on appliances. Maintenance reports were inadequate and incomplete. The Columbia Housing Authority had a single inspector for 2,600 housing units. Going to your point, Judge Wynn, about willful blindness, I don't know how busy one man could be to effectively inspect 2,600 units, but that's all they had, which was not enough, according to Holbrook. And lastly, this is the conclusion of the fire chief and police chief. Quote, the death of Calvin Witherspoon. And by the way, Your Honors, there was also Derek Roper. He also died that evening. The death of Calvin Witherspoon Jr.
He died the same time as
Yes, Your Honor. There were two deaths.
different unit.
A different unit.
And were there sicknesses in other The other
And there were 5 other people who went to the hospital.
Did any of them have any of symptoms before this
Your Honor,
incident?
that's your point is exactly right on. How could I go to a medical record that said I was feeling tired today? I feel like I have the flu. I feel like I'm sick. Unless they were specifically testing and looking for carbon monoxide, there is no way you would put those two things together. Lastly, and again, the conclusion of the fire chief and police chief. The death of Calvin Witherspoon Jr. was totally preventable through regular maintenance, but this is another crucial fact. Again, preventable through regular maintenance. There was a perception and belief by many of the people who lived at Allen Benedict that if they complained, things would not be fixed. Your Honor, if we're going to require actual notice, what we're doing is we are returning to an intent to harm standard. We are going to premeditation. The Columbia Housing Authority says exactly what your point was Judge Wynn. We are not going to do anything on our properties till someone dies because that one's free. No matter how horrible, we can have exposed fire, we can do anything, but we can say, you know what? Until someone dies, we don't have to look. Going back to your opinion, Judge Gregory, Chief Judge Gregory, you're encouraging every municipality, even though it's legally required to have a speedometer, tear those speedometers out of your cruisers. Because you know what? You'll be able to come in court and say, I didn't know I was speeding. And because I didn't know I was speeding, there's no way I can be deliberately indifferent because I had no actual knowledge that I was speeding. Even though I saw trees going past me very fast, even though the fact that I was moving through traffic, I really didn't know I was speeding. Even though I hit this person and sent them hundreds of miles off the road. Again, I didn't know. The law is not that much of a fool. Lastly, I want you to leave with this. I'm passionate about this case. And I apologize if on an appellate level, I've exceeded some decorum in my passion. But someone needs to speak for Calvin Witherspoon. This was a man who, in the ultimate tragedy and irony.
We do appreciate your passion.
Thank you, Your Honor.
Appreciate it, but you are an appellate court. You're a lawyer.
And I understand
So
that.
you should stick with the law. Passion will not move this court. But let me ask you this.
Yes, Your Honor.
You made these claims of official and unofficial policy on a failure to act by the housing authority.
Correct.
And to some extent, you characterize them being affirmative acts. Aren't they more appropriately characterized as omissions?
No, Your Honor, because they created the conditions. When you put, and this comes back to the knowledge, the fact that a fuel-fired furnace emits carbon monoxide is a fact. As soon as you put a fuel-fired furnace in a place, it is going to vent, it's going to create carbon monoxide. It must be vented. That's a byproduct of science as a result of fuel being burned. That's exactly what's going to happen. So they created the dangerous condition. And because they created that dangerous condition, they have an obligation to it, especially for the points you raised, which is this gas is so ultra lethal, there can be no defense to it. One last point, Your Honor, and I see that I'm briefly over, but I would like to just close with this. The Housing Authority created the life-threatening conditions that killed Calvin Witherspoon over a period of decades. They knew those conditions were life-threatening because they said so in their own official policy. They willfully disobeyed the laws of the state of South Carolina and the city of Columbia that would have prevented his death. And now, on a pleading level, when asked to be held accountable, they are simply arguing, we get a pass because we didn't know.
Well, you said something that was interesting that, and not talking about passion, but talking about the facts. You allege, as you read, that upon inspection, they found that the debris was visible in the unit, and that debris would cause the vent to stop up, and the stop up vent would cause the emission of carbon monoxide.
Right.
And even their own defenses said, we did inspections. So you've shown, but pled that if you did inspections, you would have seen the debris that has been established to be there long enough, and you knew that the results of the debris being there was deadly.
Your Honor, I couldn't agree with you more, and especially when you are dealing with something this lethal. The ability to correct this was slight. Go one step further. All I had to do routinely walk through with carbon monoxide test any kind of maintenance, but one inspector for 2,600 units in an apartment is clearly in a complex is clearly insufficient. And those, again, Your Honors, were the findings of a police chief and a fire chief. Those were not allegations. Those were findings by trained professionals of the city on the ground who looked.
You're better off, unfortunately, it's a tragic case. You're better off, in fact, if he actually or she went to that unit and inspected that one. Because one is based on not enough people to get to all of them, but the evidence shows that no, you got to that one. And if you saw it, you'd seen the debris. I mean, so it's the facts in terms of at this stage to say that. But anyway, I'll leave that alone. But go ahead.
And last, Your Honor, it's just simply this: we cannot return to an intent to harm standard.
Right.
If actual knowledge is where we are subverting Sacramento versus Lewis. We're overruling Dean versus McKinney. We're turning all of 1983 law upside down on its head.
All right.
Thank you, Your Honors.
Thank you, Mr. Rizek and Mr. Turner. Thank you so much for your assistance in this case and these difficult questions. We'd love to come down and greet you in our normal Fourth Circuit practice, but we cannot. But know very well that we appreciate your being here and we wish you well and stay safe. Thank you.
Thank you. It was an honor and privilege.
We'll proceed to the next case.
would have been issued, I think, under certain regulations. It has, if you look at the operating procedure at the first page, it has the specific regulatory authority. But the disciplinary hearing is a due process. It says on page 2, the disciplinary hearing is an administrative due process proceeding. You have to have a hearing in order to be able to be convicted of the offense. On page 13, it says that that once you have a conviction or a second conviction for offense, that's what and it makes you eligible for review for a possible security level increase.
Well, I don't know.
So I think
I don't know exactly what your opponent's going to argue, but I suspect he's going to say there was a Roseboro order issued in this case. My question is, how do you avoid the effect of that, and can it be avoided by the fact that the trial judge knew of these disputed facts about the video?
the Roseboro notice it doesn't affect the analysis for the due process claim because that was dismissed at the pleading stage. And so I think there's no question that that should be reversed and reinstated. And there's a state created liberty interest as recognized by the Supreme Court and the authority I cited in the briefs. It should can be allowed to be further developed. In terms of the Roseboro notice, Floyd, I think Judge Floyd, I think that goes to the retaliation claim that was allowed to proceed, and the Roseboro notice was given with the defendant's answer and motion for summary judgment. I'm not disputing that they provided a had the opportunity to or was given notice that he could provide additional materials. We never had the opportunity to take discovery as to sufficient retaliatory intent. But on that point, I do think there is sufficient evidence in the record to preclude summary judgment as to the First Amendment retaliation claim. And the reason is that there's no question so Shaw needed to establish two things to establish a substantial or motivating factor, or that his protected conduct was a substantial or motivating factor in the defendant's adverse action, which would be the refusal to review the video and send it to Supermax. And to establish that, he needed to show that they knew about the protected conduct and that there was close proximity and timing. And there's no dispute that there's a close proximity and timing here. It was just mere days between writing his letter to officials outside the prison on August 9th and then the conviction on August 17th. And in the interim, he wrote several other correspondence to officials. He wrote on August 10th, he wrote an informal complaint, which Unit Manager Murphy reviewed, that says he's already written to Richmond already, but he's trying to give officials in the prison a fair chance to respond. And Unit Manager Murphy would have received that before, he received that on August 21st and conducted the institutional class review on August 22nd that led to recommending Shaw to be transferred to Red Onion. So I think those are, that's, the timing is there. There's knowledge because he alleged that the prison officials were opening bulk mail, and he provided contemporaneous evidence of that in the form of his August 15th and August 16th letters.
Is timing enough on a summary judgment to show causation?
It's timing and knowledge, and you can establish knowledge through circumstantial evidence. Defendants didn't deny that they were aware that they were opening bulk mail or that they were aware of his correspondence. And so I think under the Martin versus Duffy same decision test, Shaw has established that it's a substantial motivating factor, and the burden now shifts to defendants to say that they would have taken the same action anyway. But again, they have offered
He was already in segregation when he got that letter, wasn't he?
He was in segregation when he wrote the letter, but the letter prompted the defendants. They don't say that they would have still refused to review the video without the letter. It's the letter that prompted the defective nature of the hearing. And in fact, it's after August 4th that there's no hearing is rescheduled. The 15-day time period within which to schedule a hearing is expired. And so he's caught in limbo, held in pre-hearing segregation with no hearing scheduled indefinitely prolonged. This is what he actually wrote his letter to Karen Stapleton on August 9th, complaining that prison officials were manipulating the operating procedure to do exactly that. He exercised his First Amendment right to complain about that. And instead, within days, they convict him at a procedurally compromised hearing.
Well, let me ask you this. Did the defendant's plea qualified immunity as to the procedural due process claim?
They did not, because they didn't have an opportunity to do so. The procedural due process claim was dismissed sua sponte by the court before defendants were instructed to answer as to the retaliation claim.
So what are we supposed to do with that? Because, like Judge Wynn, the procedural due process claim, it looks like he erred, but at the end of the day, it's going to be a qualified immunity defense, I think.
No, I don't think there will be qualified immunity at the end of the day. But the court can remand for the district court to consider that issue in the first instance. The reason why it's not qualified immunity is Lanier, which recognized or confirmed these rights at 2019, was based, undergirded by existing and controlling Supreme Court and Fourth Circuit law. In Wolf, the Supreme Court held that a prisoner has a disciplinary hearing has a right to present evidence in his defense. A prisoner also has to be given a reason for the denial of the refusal to consider the evidence. That's the Supreme Court's decision in Ponte versus Real. And the Fourth Circuit has held that documentary evidence includes video. So you take those three decisions together, it's clearly established that the refusal here to review the video was a denial of due process. In addition,
Lanier post-dated these events.
That's right, but the language of Lanier says it, quote, reflected existing and controlling Supreme Court and Fourth Circuit law. So the law was clearly established even before 2019. I don't think it's a stretch to say that those principles which were articulated.
You're saying Lanier essentially said it's clearly established.
Lanier confirms the right that was pre-existing. And it was also decided in based on, quote, a universal consensus of persuasive authority.
That case uses language like this. It says, for the first time in this circuit, presidents have a right to present video evidence. How is that clearly established?
That's right, but the clearly established.
That means those words meant nothing for the first time in this circuit.
It doesn't mean that it means nothing. The Fourth Circuit specifically adjudicated those rights for the first time. But to be clearly established, you don't have to have a right that's specifically adjudicated. It can be manifest in the constitutional principles. It could be, as Chief Judge Gregory, you acknowledged in the Booker decision, it can be reflected in a consensus of persuasive authority.
I wish that law was as clearly established as you were saying. We know from the Supreme Court that that whole principle clearly established is really up in the air right now, circuit, and we're looking in the Fourth Circuit here. I think when we say for the first time in this circuit, we aren't talking about the first time adjudication. That's kind of what it has to be. It has to be at least now. Could one day be, if certain justices get that way, it may just have to come from the Supreme Court. Right now, if a circuit has it in there, we made it clear in that case that it is now. But to use that case to say it already existed might stretch it a bit.
I think Lanier is shorthand for the existing body of controlling law that pre-existed and was merely confirmed because it was presented in a contested case where there were two litigants who were fighting over that adjudication of that right. On qualified immunity, Judge Floyd, I suggest that your decision in Williams versus Strickland is very instructive, because there, I think you said that we can expect officers to draw logical inferences, reason from analogy, and exercise common sense. And if X is illegal, then Y is also illegal. Here, there's no dispute that under the Supreme Court and Fourth Circuit law, under the Supreme Court law, documentary evidence has to be provided, and you have to provide a reason for denying it. The only wrinkle is video evidence. And I think so if you say it's illegal to refuse consideration of written testimony, then it's illegal to refuse consideration of video testimony, particularly where
1,000 words. A picture is worth 1,000 words.
Yes, I think it could go to disputing the credibility of the prison guards version of events, which again, if you look at JA 185, it says this is the reason for the decision of the conviction. And the hearings officer says that the reporting officer stated that she was, quote, for certain that this was the offender. And then it goes on to say the offender did not have enough evidence to support his defense, but he requested the video repeatedly over weeks to multiple officials in different informal complaints. He went on a hunger strike. He raised this issue repeatedly, and yet they refused to consider it and offered no justification. Even in the administrative record, in the district court, and even now on appeal, they have not offered no valid penological justification. I see that my time is up, and I'd like to reserve remainder for rebuttal unless the court has questions.
What you have reserved. Thank you. Mr. Croslow.
Thank you, Chief Judge Gregory. Good morning, Your Honors. May it please the court. I'm Lucas Croslow here for the appellees. At the council table is Jordan Minot, Assistant Solicitor General. I'd like to note at the outset that a lot of what you just heard from my friend on the other side, like a lot of what's in Mr. Shaw's briefs, is nowhere to be found in his numerous papers submitted to the district court. Excuse me. Mr. Shaw filed a complaint. He then filed a clarified and particularized complaint. He filed 2 letters, further clarifying his.
I think it's okay if you want to take that mask, if you're comfortable with it.
Thank you, Your Honor.
That okay?
That's much better. Thank you. And despite all of these papers filed with the district court, many of the claims that have been asserted here on appeal simply weren't asserted below and are clearly waived. I think 2 examples are especially glaring, and I'd like to highlight them here. First, Mr. Shaw never argued below that there was a deprivation of due process in connection with the failure to review video evidence. The failure to review video evidence, in Mr. Shaw's view, up until he was here on appeal, was retaliatory on the part of prison officials. It was not a deprivation of due process. In fact, Mr. Shaw expressly disclaimed any due process claim against hearing officer Lebo. That's at JA 71, which is Mr. Shaw's amended complaint. And it was hearing officer Lebo that conducted the hearing and found Mr. Shaw guilty. So any due process claim relating to the conduct of the hearing, and in particular with regard to the failure to review video evidence at the hearing, is not only not clearly stated in the complaint, but even expressly disclaimed by Mr. Shaw below and can't be advanced here for the first time on.
But counsel, we talk about a pro se litigant, and wouldn't it follow that if you're saying you retaliated about this video, that he's claiming that there's something favorable to him, why they don't want it disclosed? Why wouldn't that follow in terms of logic and common sense?
Well, Chief Judge Gregory, I don't know that there's any allegation that anyone reviewed the video, so I don't think it's necessary. We can necessarily infer.
But no, that's what his point was, that he hadn't seen it either, but he was there, and he said if the video is what it purports to be, an accurate depiction of what happened, I know what did not happen. Therefore, the video should establish that I didn't do what I'm charged with. I mean, that's putting a high burden on a pro se to say, well, he said it, but he didn't get the Simon Says, the lexicon of legal lexicon. But it's clear he's saying that video is important because the video will tell the truth, and we can get to the truth. And that's what he's saying.
I think, Your Honor, it is clear that Mr. Shaw repeatedly said that the video might be exculpatory. I think it's clear that he considered the video important. I don't frankly know why Mr. Shaw did not choose to make a procedural due process claim based on the lack of review of video evidence. I just know that it's quite clear from the record that he did not do so. And I think that—
Did he request the video in the record?
Sorry, Your Honor.
Does the record establish that he requested video?
Well, I don't know actually, Your Honor, whether it's perfectly clear that he requested review of the video at the hearing itself. I know that he did request from numerous prison officials, including some of the named defendants, that they review the video evidence, and they refused to do so.
Why would they do that?
I don't know, Your Honor. I frankly don't know the answer to that question.
You come here saying we should rule in your favor, and you don't know a key question. So you can't say it wasn't important, can you?
No, no, Your Honor, I can't necessarily.
And you can't say that it wasn't exculpatory, can you?
I cannot, Your Honor.
Okay. But
No.
you're saying that he didn't put the right pegs in the right hole because as a pro se, he didn't articulate the legal standard, right? That's
Well,
what you're
respectfully, Your
saying?
Honor, I actually think it's a little more than that, because I
Okay.
think this is not a case like one of the cases mentioned by my friend, where there's ambiguity in the complaint or where the complaint is inartfully pleaded. This is a case where the complaint is actually quite clear, and the clarifying letters submitted to the court by Mr. Shaw are quite clear. And there's an express disclaimer of any due process claim against the hearing officer. And again, Your Honor, I don't know why Mr. Shaw didn't choose to bring any due process claim against the hearing officer, but it is quite clear that he did not. And to allow him on appeal to revivify his due process complaint, and not only in general, but against a particular defendant that he never brought a due process complaint against before, and allow him to advance an entirely new theory based on the facts that he's pleaded, I think goes a good deal beyond, deference to pro se litigants. I think it's creates a real notice problem to defendants who are trying to defend against complaints like this. And I think it would be to fault the district court for something the district court was not.
Does it matter that he repeatedly asked the officials to view this evidence? He's got letters all over the place. I mean, there is I guess, in terms of, well, they didn't know about it for the first time, in terms of maybe a pro se litigant didn't put it specifically in the complaint. But they got letters all over the place where he's trying his best to get this video evidence. He's going complaints and all kinds of stuff flying around. It's clear to them wants it. Maybe it's a lawyer and judge question is whether, well, if he didn't put in complaint, they didn't know anything about it.
I agree, Judge Wayne. It's clear he wanted the video, and he certainly said so.
And he's pro se. That's the thing. But let's okay. We probably can. We will have to decide that issue if I don't say if we assume he did plead it. Then we get to the merits of this thing, and then the question is: did he allege a sufficient liberty interest here? And he says he alleged that avoiding being placed into a supermax facility. If we get there, isn't that sufficient to establish a liberty interest?
If it were the case, Your Honor, that he had alleged that
that way we will assume. We will
If we were to
assume
make
that
all those
now
assumptions.
we're going to talk about the merits of the case.
Yes, Your Honor. If we were to make those assumptions, then I would agree that there's a liberty interest. I think it's clear there's a liberty interest in not being placed in a supermax facility erroneously. I don't agree, and I don't think it'll be a surprise to you that I don't agree that that theory was adequately pleaded below. And in fact, the reference that my friend made to the joint appendix at page 211, that's Mr. Shaw's summary judgment opposition. That was not an argument, again, that Mr. Shaw was making with regard to his due process claim or with regard to a liberty interest in not being transferred to a supermax facility. That was an argument Mr. Shaw was making in connection with his retaliation claim when he opposed the defendant's motion for summary judgment. So this is another theory that I do not think was adequately pleaded below. And I don't think that either the district court or the defendants could have been expected to understand that Mr. Shaw was attempting to advance a due process claim where the asserted liberty interest was not being transferred to a supermax facility. The district court.
At what point was he entitled to have counsel in this matter here?
I don't think he was entitled to counsel per se in the disciplinary hearing. I know he was entitled to have some sort of a person with him of his choosing.
How about in the complaint itself? Is there anything that would say he would be entitled to a counsel?
In the district court, Your Honor?
Yeah.
Not that I'm aware of. I mean, it's certainly within the district court's discretion.
So when did he become entitled in this process to counsel?
It's not clear to me, Your Honor, that he is entitled to counsel. This court obviously chose to make that appointment in its discretion.
When could he have been appointed one in the process, if you know?
I'm sorry, Your Honor?
When could he have been appointed one in the process, even in the discretion of the court?
I honestly, Your Honor, don't know the answer to that standing here. I would imagine the district court could have done it as soon as it received the complaint.
It would seem as though, if you're going to hold a pro se litigant to the standards of a lawyer, and then after the complaint comes in, you then appoint a lawyer, you wouldn't approach that complaint as though a lawyer drafted, unless you want to appoint a lawyer before the complaint. Maybe you would draft one and submit it to a lawyer, and then the lawyer would put it in. But it seems to be, I heard this earlier in an argument this week, so you're the beneficiary of me getting it. But one of the councils argued, well, maybe he should be getting a lawyer quicker in the process. I hadn't really thought about that. But there seems to be some disconnect here. And I agree, when you're dealing with pro se, sometimes you're better off being pro se than a lawyer because you can get the benefit of stuff that a lawyer doesn't do, you won't get. If a lawyer you're a lawyer, but if you're pro se, you might. But this is one of those instances where he's got letters all over the place, making this point. And then he does this complaint is inartful. Maybe the brief might be inartful, doesn't quite go there either. But the question that comes to us, you're saying procedurally this thing is defective. But if we get to the merits of it, that a potential liberty interest then exists. That presents a conundrum for us. And we've had cases all over the board dealing with these pro se type issues. And maybe one day that has to be dealt with. Is what are there different rules that apply? And clearly there are, because there are instances where pro se complaints are viewed broader than if you as a lawyer draft them, and because there's a little bit of liability attached to them if you fail to do it like you're supposed to. But there's no lawyer that's not. So
what do we do with we have the Lanier decision decided, but after that, Tyler versus Hooks was decided, and it said the court expressly held the right was not clearly established prior to Lanier as to the video evidence, and Lanier is after this incident, right?
Yes, Your Honor, that's right. Yes, and I certainly agree. I think it's quite clear from both from Tyler and from Lanier that this was a newly established principle in the Fourth Circuit that prisoners are entitled to the review of video evidence. My friend on the other side cites what he calls a persuasive consensus, but the standard is that the persuasive consensus has to put the issue beyond debate. And I don't think there's anything to suggest that this question was not still debatable in the Fourth Circuit up until Lanier was decided. And so because Lanier postdates this case by the relevant events in this case by several years, I think there's no real argument that there was a clearly established right.
So you say there's no way to get around Tyler versus Hooks.
Agreed, Your Honor. And Lanier itself, which of course says it's deciding the question for the first time in this circuit. Yes, so I mean, my friend on the other side in his briefs has said that the way around Tyler is that it was an AEDPA case, and Tyler does mention that that the answer in Tyler was all the more clear because it was specifically Supreme Court precedent that was relevant to the decision. But that's only a buttressing point in Tyler. Tyler does quite clearly say that the right was first clearly established in Lanier, and I think that's clear in Lanier itself as well.
Well, to be fair, Tyler that's a different type of case. It wasn't really a qualified immunity case. It dealt with DEPTA type action in which Supreme Court's already said that has to be clearly established under federal law as determined by the Supreme Court. Totally different case than what we're dealing here. I mean, the point you make in terms of Lanier saying first time on the circuit, that's pretty good stuff. But I don't think Tyler's getting you there.
I agree, Your Honor. Tyler itself may not get there because of the distinction that you've noted, but I think between Lanier itself saying it's establishing this right for the first time, and then Tyler reinforcing the point, I don't think that it could really plausibly be argued that this question was put beyond debate until Lanier itself was decided. So there's certainly a qualified immunity defense if the case were to be remanded and the due process claim revived. There'd be a qualified immunity defense based on the fact that the officers could not have been reasonably on notice of an obligation to review the video evidence. I do want to touch briefly, Your Honors, on the retaliation claim and the causation issue that Your Honors noted in my friend's argument.
Now let's be clear. What were we just talking about right then with regard to qualified immunity? Was that a retaliation claim?
Well, I think it goes to both, Your Honor, but Lanier itself was in the context of it.
I want to keep it separate. That's First Amendment retaliation claim. I thought you were talking about qualified immunity regarding the retaliation claim from that perspective. On the procedural due process claim, we're dealing with a whole different type of issue. So that's why you're confusing me. He says, you closed off as though now we're going to talk about retaliation. I thought we just finished talking about it, or didn't we?
Well, Your Honor, we've been talking about both in a sense.
But
Precisely
that,
because
but the qualified immunity is going to that retaliation claim. Or is it not?
I think it goes to both, Your Honor, because there would clearly also be qualified immunity as to the due process claim. It is true that the defendant did not have an opportunity to file an answer to a complaint that included the due process claim because that claim was dismissed by the district court sua sponte before defendants filed their answer. But I'm happy to represent that there be a qualified immunity defense pressed by the defendants as to both claims on remand. And it, I think, would be equally persuasive as to both claims. I was pivoting in the sense that I want to make sure we cover the causation issue, which we've not yet spoken about, which is that Martin v. Duffy certainly did establish a new legal standard for causation, at least in what it called dual cause cases or dual motive cases. But that a new standard did not actually make a difference as to this case, which of course was decided by the district judge without the benefit of Martin v. Duffy. And the reason it doesn't make a difference is because, well, for two reasons. First, Martin still requires the plaintiff to make a prima facie case of retaliation, which, because there's simply no evidence to support causation here, Mr. Shaw failed to do. And the second reason is that there's only a difference between but-for causation and the same decision test that's put forward in Martin v. Duffy if you're dealing with a dual motive case. And here we're simply not. The dispute here is not over which of two causes was the reason for the allegedly retaliatory acts. The dispute here is whether the protected First Amendment activity had any causal connection whatsoever to the prison officials' actions. And the answer is no, because there's no evidence in the record that prison officials actually even knew about the protected First Amendment conduct. And I want to address that in kind of two tranches. The first tranche is with regard to the protected First Amendment conduct that Mr. Shaw was actually talking about in the district court. And that's his two letters to Ms. Karen Stapleton, who's a VDOC official here in Richmond. Mr. Shaw asserted that he was being retaliated against by prison officials because they became aware that he was writing to Ms. Stapleton about what was going on at Sussex One State Prison. All we know from the record is that at most, one prison official eventually became aware that Mr. Shaw had written to Richmond. And that's by virtue of the August 10th informal complaint that Mr. Shaw filed that it was routed to Mr. Murphy, Defendant Murphy. But Mr. Murphy did not definitively see that informal complaint until August 23rd, which is not only after the disciplinary hearing took place, it's also after Mr. Murphy made the recommendation to transfer Mr. Shaw to Red Onion State Prison. The August 21st date that my friend referred to is the date that that informal complaint was stamped received. We don't know received by whom, but it's not, I think, fair to infer that it was received by Mr. Murphy. It was received by some prison official and then assigned to Mr. Murphy, who signed that he had seen it as of August 23rd. So
which way are these inferences to be drawn in his favor of the prison?
Well, Your Honor, I would note, first of all, that there's actually no evidence in the record that was put there by Mr. Shaw. He didn't submit any affidavits or declarations. And
was he given notice that he could have discovery?
He was given notice in two orders of the district court, Your Honor, that if the defendants were to move for summary judgment, that Mr. Shaw would have the opportunity to submit affidavits, counter affidavits, declarations, and that he could request additional time to gather more materials, which he did not do.
That's not discovery, notice of discovery.
I think, Your Honor,
that's notice that I can submit something that I have already. Discovery is to discover. That's what the word means, what it says. I mean, I don't need to discover what I know I have. The question is, he was not told that he had an opportunity to have discovery.
I don't know, Your Honor, whether it was ever expressly communicated.
It was not. The record clearly shows that.
Well, I think
but that's my question is, to whom should the inferences favor? You or Mr. Shaw? You never answered that first question.
Well, the facts and evidence, Your Honor.
Because you don't like the answer? The answer is Mr. Shaw, isn't it?
Yeah, of course.
Let's deal with the facts and the law first, and then you can explain why you think I should eschew that law and then rule in your favor. But he wasn't told that, was he?
Well, I'm certainly not recommending, Your Honor, eschew any law. And I think that it's certainly the legal standard is that all the facts have to be construed.
Because you're about to say, well, best who received it, when at most he got it on this date, Those are all inferences that you're drawing in your favor. I just would listen to your colloquy about that. Well, the best that maybe how do we know that he got it? Maybe he didn't. How do you know? Well, it was there. It was in the milieu of where his job is in terms of Department of Correction, right? Correct?
Yes, Your Honor. Well, I
Well,
think
so we sit here, you want us to just whisk away all of these facts in your favor in a pro se case, and where in this case, you didn't look at the video, which I just don't understand that. You know, a place that's, I don't know, you got people there who are serving time, probably so, for breaking the law because something about truth they didn't honor. But if you have a video, and why wouldn't you? I mean, maybe I'm just old school. I mean, just the way I grew up in, you know, down in Petersburg, I mean, it was a small town, but my parents taught me a lot about common sense and fairness. If you're charging somebody that eventually led him to go to Red Onion, why wouldn't you say, look at it? Why? I mean, it's just, I don't understand. Are we bereft of common sense anymore? Why? I mean, why is that a prison? Why did someone have to tell you that? You know, we'll wait for a case to see whether or not that's appropriate. What about wait for the fact of what humanity is and justice? Can you answer that for me? You represent him. Do you know? If you don't know, that's fine. But I just don't understand why not. If it shows that he did it, you should be great. Maybe this case would have come. Look, that's you right there, doing exactly what you did. But when he's saying, I didn't do it, look at the video that you have. Didn't you have it?
as far as I know, Your Honor, I do see that my time is
No,
expired.
that's right. You're fine. I'm the chief, and I'm asking you a question. You're fine.
As far as I know, the video was in the prison system. There's nothing.
Right. They had it all the time, and they still have it. Right.
I don't actually know the answer to that for certain, but I don't know that they don't.
But certainly they wouldn't destroy it.
I wouldn't think so, Your Honor.
No, I wouldn't either. So they have it. And when we spend all this time through all the court and all those things, when you have just something simple, you know, it just makes you wonder where we gone in society now. I mean, why not?
I don't know the answer, Your Honor. I'm afraid.
I don't either. Okay, but if you go ahead, I disturb your last moment, so you can go ahead and take a minute or so.
No, that's quite all right, Your Honor. I think the 2 points I'd like to emphasize in conclusion are simply that many of the theories that have been advanced here on appeal, as Your Honors can tell from the record, were not advanced in the district court. I certainly recognize the conundrum Judge Wynn referred to, and I recognize the need to show special solicitude to pro se litigants. But I think it would be a bridge farther than this court's been willing to go in the past to look even at the facts that were pled here and to suggest that the district court should have derived legal theories from them that Mr. Shaw expressly disclaimed below. So that's my first point. And my second point is simply that even if the court were to evaluate these waived arguments on appeal, they still fail. And on remand, there would still be a very weighty qualified immunity defense as to both claims. So we would urge the court to affirm. Thank you.
Thank you so much, Mr. Crosslow. Mr. Stevenson.
Thank you, Your Honor. Few points on the issue of waiver. They addressed this at the reply brief at page 16. The disclaimer against Labo is made in the context of the due process claim about being continued in segregation, but that doesn't discount from the fact that the thrust of the complaint is that he is continually upset that the defendants have refused to review the video. And indeed, he said hearings officer Labo is personally involved because she conducted an untimely, invalid disciplinary hearing for the purpose of finding me guilty of a disciplinary offense that I was wrongly accused of committing and then transferring me. And that's at J 75 to 76. I think one of the questions was, does the record make it clear that he requested the video at the hearing? Yes. If you look at JA 25, he says, instead of looking at the video evidence, Labo chastised me for wanting to rely on the video evidence.
He was chastised for wanting to rely on the video evidence.
Correct. Yeah. And then also, I think there was a question about whether he alleged a sufficient liberty interest. And colleague said that the reference that was made was in the opposition to summary judgment. I think you can consider the whole record here on appeal, but you look at JA 48 and 51, he alleges in his initial complaint that he was being transferred to the most restrictive prison in Virginia. So I think that suffices, and they concede that there is a protected liberty interest in erroneous transfer to Supermax prison. I think that warrants reinstatement of the claim. As to, I think Chief Judge Gregory, you made the valid point that he shouldn't be penalized for trying to put the right, doing his best to try to put the pegs in the right holes here. And the court's decision in Starbuck is instructive, where there was a pro se plaintiff, and he raised a new legal theory on appeal, and the court said, well, we'll look to the facts that were alleged in the complaint. And here the complaint and record is suffused with allegations about failure to review the video. As to qualified immunity, I think the court could reach that decision and hold that it was clearly established. I don't think that the phrase "first time in the Fourth Circuit" necessarily means that it was only clearly established at that time, because the law that Lanier was relying on was reflected existing and controlling Supreme Court and Fourth Circuit law, and was based on, quote, universal sister circuit authority. That's a consensus of persuasive cases and another way to find qualified immunity. But if there's any doubt, the court can remand and have the district court address that in the first instance. Indeed, the appellees in their brief at page 50 cite a case from the Third Circuit, Burns, that said it was inappropriate to consider qualified immunity at the appellate stage when the district court had addressed it. I think Judge Wynn, you asked about when is it appropriate to have counsel appointed. I would just point out that at JA 70, he does, Mr. Shaw does say that legally, I can't prove it without some help. So he's referring to his allegation against Unit Manager Foreman's involvement. And I think it's clear from the pleadings that he's doing his best to articulate claims, and we shouldn't penalize him for making the best efforts in terms of the right legal nomenclature. And the Fourth Circuit's decision in Gordon versus Leak is clear that if the civil rights pro se plaintiff can't articulate the correct legal theory, then it would be appropriate to appoint counsel on remand. So I think with all those points, unless the court has further questions, I'll rest on the briefs. Thank you.
Thank you. Mr. Severson, I note that you are court signed. I want to express on behalf of the Fourth Circuit, and thank you for your service and other lawyers like you who take on these cases for indigent clients and represent them before the court. We rely upon that expertise, that assistance, and thank you. And also, Mr. Groslow, of course, of your able representation of your client as well. We can't come down and greet you as we'd like, but know that very much that we appreciate your being here, and we wish you well and be safe. Thank you.
Thank you, Your Honor.
We'll take a break. Mr. Witt, when you're ready.
May it please the court. I'm Rob Went from Charleston, South Carolina, and I represent Shelley Cannon, the claimant in this matter. Before I begin on the merits of the case, I would like to make a brief clarification of the record, if I may. The commissioner has made a number of representations about the facts of the case, and we have disagreed with that, and and put that in our reply brief. But there is one clarification that I think is important because it colors the case. On page 2 of the commissioner's brief, it stated that Ms. Cannon managed about 100 employees, and that's not correct. She was the preschool director for a Baptist church, and according to the record, she supervised 6 people during that program from Monday through Friday. And then on Sunday services, when they ran the nursery, she supervised about 9 people while the parents were in the services. She was a high school graduate, although she did take some college courses for about a year. But she also notably only earned about $18,700 a year. That's the most she earned doing this work. So she's just not a high-powered managerial type. She was just a regular person running a program, worked very hard for very little money, and was very stressed out by that. Now, there are 2 issues before the court today. First of all, whether the evaluation by the ALJ of the opinion of the treating psychiatrist, who was a board-certified specialist, whether that was done properly, and whether the ALJ failed to follow the procedures under the regulations for the evaluation of medical opinions that applies to this case, the old medical opinion. And did the ALJ follow the holding in Dowling from this court about the need to address all of those factors? The other issue, of course, is whether the ALJ properly evaluated Ms. Cannon's subjective symptoms. Now, the underlying error for both of these issues is whether the ALJ built an accurate and logical bridge between the facts of the case and the ALJ's conclusion. Now, the ALJ decision has lots of facts. The record is described in a pretty good bit of detail. And then their conclusions. But what we're sorely lacking here in the ALJ decision is an explanation of how the ALJ got there. And that's really the nub of this case. It frustrates meaningful judicial review. And under this court's holding in doubt, that very fact warrants a remand for an explanation. Now, it's important, I believe, to look at the theory of this case. Why do the facts support a conclusion that Ms. Cannon was disabled under the Social Security regulations?
How did the Dowling case and this Arcus case change this case? You've indicated that the significance of Dowling, as I understand it, it's a question of the correct legal standard that was applied in this particular case. How does that change this case from the way in which the ALJ conducted this review?
Well, what the ALJ, the ALJ has just not explained a number of different conflicts in this record.
I'm speaking to the law. How has the law changed?
Oh, well, the law really has not changed that much under the new regulation. I'm sorry, I misunderstood.
How did Dowling and Parsons change it? Those 2 cases, did they change at least the legal standard or articulate it or indicate it differently?
Mostly it's an articulation of what the regulation said, which requires the old regulation, which is the operative regulation in this case, says that the adjudicator must address, the commissioner must address all opinions and give an explanation that makes it clear to other reviewers of the decision of how the.
What was the legal standard that ALJ applied insofar as considering the treating psychiatrist's opinion?
Well, it's here we get to substantial evidence and the failure to explain how he got to this point.
Was that standard that applied, was that incorrect or was it correct?
The ALJs, the standards,
Yes,
the
the
ALJ.
legal standard that the ALJ applied when considering the treating psychiatrist's opinion, was that a correct standard?
He did not address all the factors. The factor he did address, that was the correct standard. And what he addressed was the consistency of the opinion with Dr. Beal's own records and with the other evidence of record. And that was flawed because those findings of fact are not supported by the record. The rest of it, he just doesn't explain. And there are numerous other factors, in particular, the factors dealing with with Dr. Beal's status as a treating psychiatrist who treated Cannon a lot over a long period of time. And
Well, was the ALJ required to specifically enumerate each of those factors in considering Dr. Beal's testimony?
well, he was if those factors are important to the outcome of the case, and the court cannot determine exactly how the ALJ reached that conclusion. And in this regard, and I would like to go back because I think it's important to look at what is the theory of disability in this case, and why does that opinion matter, and why did it matter that the ALJ did not articulate the reasoning behind these factors? Well, first, Ms. Cannon was disabled because it's step 5 of the sequential evaluation, because the ALJ found that she could not return to past relevant work. Then we moved to step 5, and at that point, the issue is whether the claimant is able to sustain in this case, the mental demands of work on a regular and continuing basis, 8 hours a day, 5 days a week. That's the legal standard. There are two issues under that particular theory. One is the vocational expert testified that an individual, that there would be no jobs at step 5 of the sequential evaluation in the national economy to an individual who was off task more than 1 hour a day. And also there would be no jobs at step 5 of the sequential evaluation for an individual who was absent from work more than 2 days a month on a regular basis. And that's really critical because when we look at this record, what we see are a number of severe symptoms of mental illness, which are persistent. And just like most cases involving these mental illnesses, the patient has good days and bad days. It's an up and down. It's not a straight line, the degree of severity. But what is clear is that the mental illness was severe, and that was part of Dr. Beal's opinion. And he also stated that she would require lifelong aggressive treatment to prevent worsening of her state and to reduce the number of hospitalizations required. And that's exactly what happened. She underwent extensive counseling. She underwent not conservative, but actually aggressive treatment with the TMS treatment. She was considered for electroshock treatment, and she was managed on lots of medications, which were changed when her symptoms did not appropriately respond. So one question that comes up right away is, how could anyone sustain work on a regular and continuing basis, 8 hours a day, 5 days a week, when they're undergoing that much treatment in and of itself, not to mention the episodes of increased symptoms, which she clearly had with these ups and downs? How could she not miss too much time from work? The other issue, one of the many symptoms that she displayed, and which are well documented in this record, are her affect and mood. That is, she's always tearful and crying. And she complained that she had crying spells all the time, and that when she went for treatment, and she testified to this and also indicated in a function report form that Administrative Record 204, I believe is where that's found, that when she would return from her appointments, she would cry the rest of the day and couldn't get anything done. Now you have to ask the question, how could a person who is crying all the time. And all these encounters, every single doctor she sees notes that she's crying or is tearful during these encounters.
I guess in following you, I'm trying to understand. We could go back and forth and say that question. How could we believe that? But I thought your case would turn upon how the ALJ handled this treating physician or psychiatrist's opinion. In the first instance, as to whether the legal standard, and then secondly, regarding the medical record as to whether it's supported by substantial evidence in the case, and why he would have a different opinion that's inconsistent from Dr. Bills. I mean, you have to ask yourself, that's not going to help you one bit that I can see. We can go back and forth, but the question is what did the ALJ do wrong in this case that would entitle you to a rehearing, remand, or reversal on it?
Yes, sir. And Judge Wynn, you're absolutely right.
So which one of those are you addressing right now?
Well, it's not for this. Well, it is the legal standard, and it also is substantial evidence, and it's not for this court to make these decisions.
But you agree that you're not contesting the fact that ALJ did not find the psychiatrist's testimony to be controlling.
Oh, absolutely. And it's not controlling. It shouldn't be found controlling. There's other evidence that.
But that doesn't end it. So now he then has to determine how much weight he will give to this testimony by virtually of looking at factors. So I understood your brief. You were complaining that under Darwin and Rockus, he had to really go through those factors. I don't know to what extent he had to go through it, but he didn't go through it to sufficiently in applying the proper regulatory factors here, which is a different type of position than if you only pick out one or two of them.
Well, I agreed. I mean, this is a procedural case, and the procedure is extremely important because the court can't conduct judicial review unless these procedures are followed. And that is a holding in of this court in the Dowling case.
I mean, he gave the treating psychiatrist physician opinion a little weight, which you can do, but you got to go through the factors to do it. And the question is, did he sufficiently deal with those factors so as to lead to that result?
Well, and he clearly did not, Your Honor. And the reason is that there's evidence which we have pointed out that that contradicts his rejection of the treating doctor's opinion. And he's failed to explain how he came to this conclusion that the treating physician.
Of course, the answer determines on how he looked at those factors.
Right.
So it's not just clearly did, and there's evidence to do it. You have to look at the factors, and your answer would articulate which of those factors he did not do.
Right, and the factors that the factor he did consider is not supported by substantial evidence. The factors he did not consider are critical because according to the commissioner's regulation, the treatment relationship, the frequency of treatment, the purposes of the treatment itself, and the specialization of the medical the person giving, the doctor making the opinion. Those are all critical factors in weighing the evidence and reaching a conclusion. An administrative law judge is not a medical expert. And this is one reason why we have these regulations. An administrative law judge is trained legally. And while the judge has to try to understand medical issues, in the end, the judge can't encroach on that area. That's why the law requires the commissioner to hire a psychological consultant at the initial level if there's a mental impairment. And that's why they scheduled consultative examinations. So the administrative law judge's explanation of how he got from A to B was critical in this case from a procedural point of view. The other factors, just to go back to why the ALJ's assessment of the consistency factor is not correct, is not supported by substantial evidence. There's lots of evidence here, which we've cited in the brief, about the various findings on clinical examination that contradict the judge's finding. There are significant findings here about all of these severe symptoms on examination. And I think that unless there are other questions, I'll rest and reserve my time to respond.
Thank you, Mr. Ware. Ms. Dominica?
Good morning. May it please the court. Your honors, the district court rightly affirmed because substantial evidence supports the ALJ's decision. The ALJ fully appreciated that Ms. Cannon's longstanding mental impairments impacted her work-related abilities. In fact, the ALJ agreed with Ms. Cannon that she could no longer perform skilled, stressful work as a preschool director. Instead, after carefully reviewing all of the record evidence, the ALJ determined that Ms. Cannon could work, but with considerable mental restrictions. Simple, routine, repetitive work, no fast-paced production requirements, only simple work-related decisions, few, if any, workplace changes, and only occasional interaction with the public.
The legal issue here, at least initially, is the question of how the ALJ got to all that you just said. And to get there, there was a treating psychiatrist named Dr. Beal, gave a lot of testimony. ALJ basically ended up gave little weight to that opinion. First thing he said is not controlling. Opposing counsel doesn't disagree with that. That it doesn't have to be controlling, didn't meet to that level. But that doesn't end it. If it's not controlling, then he has to determine, well, what weight do I give this? And it appears as though he then has to go to those factors. And the question here is, did he adequately explain, in light of those factors, the level of weight which to accord Dr. Beal's testimony, which would lead to all of those conclusory things that you just gave us?
Your Honor, the ALJ did everything that was required, and that's why the district court affirmed this case.
That's a wonderful conclusion. And I'm asking you to deal with what the issue in the case. I got it. We can say that he did everything he could. He was wonderful. He did. But at the end of the day, the question comes, did he articulate and the factors that are necessary, having determined that he's not controlling, which he can do, no one disagrees with that, but he's got to figure out the weight. And to come to little weight, is that supported by his articulation of an explanation of those factors? And if it is, then address the factors and how you contend it is sufficient for him to have come there.
Certainly. If you look at the decision itself, the ALJ meaningfully considered all the relevant factors. And before I go there, I just want to point out that in Dowling, the court said the ALJ is not required to set forth a detailed factor-by-factor analysis. That will come to the conclusion
that what you're saying is he doesn't have to go through every one of them, but something has to happen, beyond just, I've looked at it and think it's okay. So tell me, how do we get there?
So on page, in Joint Appendix, page 18, we have a paragraph addressing Dr. Beal's opinion. The ALJ addressed consistency and supportability when he explained that Dr. Beal's opinion was not consistent with his own treatment notes. And the ALJ meticulously discussed those treatment notes throughout the record. And just briefly, I'll point out that the treatment notes showed that Ms. Cannon was reporting to Dr. Beal significant improvement in her symptoms. She was denying medication-related side effects. She was denying suicidal ideations consistently. She was telling Dr. Beal she was making progress in therapy. She was also reporting that TMS treatment was significantly reducing her symptoms. So that's one factor. It was inconsistent with his own treatment notes and was not supported. The ALJ also explained that Dr. Beal's opinion was inconsistent with the medical evidence of record. And here again, when you look at the ALJ decision as a whole and the pages before the ALJ comes to this analysis, the ALJ meticulously discussed the evidence that was inconsistent with Dr. Beal's opinion. That evidence included the fact that Miss Cannon had no psychiatric admissions after her alleged onset date, that her treatment consisted of medication management, psychotherapy, and TMS treatment, which was highly effective by her own reports in reducing her symptoms. We had the benefit of 3 expert opinions, 2 state agency psychological consultants, and then a person, a psychiatric examiner who met with Miss Cannon, and all 3 of those experts concluded that Miss Cannon could perform a range of simple work. And also the record showed that Miss Cannon elected to discontinue some effective forms of treatment. She stopped TMS therapy and also discontinued their her psychiatrist. Her psychologist. So there was ample evidence in this record that was inconsistent with Dr. Beal's opinion. The ALJ also addressed the other relevant factors in our regulations throughout the decision. He discussed the nature and the extent of the treating relationship when he mentioned that Miss Cannon was seeing her psychiatrist every 3 weeks. Then he discussed that she had been seeing Dr. Beal for medication management since at least 2015. Then the ALJ meticulously discussed over 2.5 years of medication management visits with Dr. Beal. So all of that analysis shows that the ALJ meaningfully considered the nature, the extent, the examining relationship, how frequently they saw each other, and the ALJ also addressed specialization. Again, he discussed that Miss Cannon was seeing her psychiatrist every 3 weeks. He talked about the medication management with Dr. Beal. And then when he analyzed her opinion, he discussed that Dr. Beal was treating Cannon since at least 2015 for her mental impairments. So the ALJ certainly recognized the specialty of Dr. Beal as well. And that's why the ALJ certainly conformed to the requirements of Dowling by providing meaningful consideration of the regulatory factors.
Is it enough to recognize it? Does it not require him to explain? And take, for instance, the situation where there is some improvement that the record shows she's having some good days. And then that indicates, well, she can do a job. Well, where does he explain that? I mean, how do you explain that as a basis for that she's having some good days, that she's then capable of employment? Or can you simply just recognize it and that's the end of it?
Well, Your Honor, it's a very fact-specific inquiry based on this particular case. And what's required of the ALJ as the fact finder is to articulate a substantial evidence to support his findings. That's the issue here. Could a reasonable mind reach the conclusion that the ALJ did here? And certainly as a district.
Well, how do we know that if you don't explain it? If all you do is say, I recognize it. Do we then read between the lines and figure it out?
Your Honor, this court doesn't require decisional perfection by an ALJ. What matters is if there's a logical bridge between an ALJ's fact finding and the conclusion, and enough discussion of the evidence.
So in other words, we do read between the lines.
Certainly, Your Honor, because we're looking at the ALJ's decision.
Doesn't that go against those 2 cases? They pretty much says you should not, Arkansas and Darwin, you should not have to read between the lines of an ALJ in order to get a consideration of the regulatory factors.
Well, I think that what I meant to say is there meaningful consideration? Like Dowling says, it doesn't require a factor by factor articulation. What the court said was, can we look at this decision and understand whether those factors were considered? And we have that. We have enough of the ALJ's articulation for this court not to have to read between the lines. The court can look and see that the ALJ discussed psychiatric treatment every three weeks, that medication management was provided by Dr.
I mean, think about the worst case scenario here from your perspective. Even if we did find that maybe he didn't do enough, what do we do? Send it back and he looks at the record and then just put a few more words in there, or maybe have some more evidence as necessary, but wouldn't be a big fix to it, would it?
Well, Your Honor, of course, our position is that the ALJ certainly did enough for this court to engage in meaningful judicial review of the ALJ's.
That would require us reading between those lines you just laid in front of us. And Darwin said we shouldn't do that.
Well, Dowling says that on the other hand, Your Honor, that express consideration of factors is not required. What's required is apparent. There wasn't even a hint of consideration of Dowling. And that's just simply not the case here. And that's what the court said. The court couldn't even reach any idea whether the ALJ had meaningfully considered those factors because there wasn't a hint of it. We have that hint here. So the court, even if I misspoke about reading between the lines, what I meant was.
I led you there, and I apologize for that. I led you there, and you used the words, and you didn't know where I was going. So I won't hold that against you.
I appreciate that, Your Honor. But what I was trying to get at is, in our cases, what an ALJ has to do is provide sufficient articulation for the court to understand fact finding. And that's what the ALJ did here. We have a compendium of evidence, substantial evidence, which is not high, as the Supreme Court has made clear. It's more than a mere scintilla and less than a preponderance. When you look at the ALJ's decision as a whole and his meticulous discussion of Ms. Cannon's treatment history, the efficacy of her treatment, her own statements to her providers. And that's a point I'd like to talk about briefly.
Before you pivot to something else, you've talked about, I think you've done a great job of explaining how they came to conclusion as to why they give a little weight to Dr. Beal. You've done that. I'd like to ask you something that I think to me is the core of the case, and that is there's no evidence she was ever relieved of her diagnosis, correct?
Correct.
All right. And what is her diagnosis that, as you can see, renders her unable to do her job?
Well, according to Dr. Beal, he said her most significant impairment is depression.
Right. But not just depression. What type of depression? That's very important in this case. What type of depression?
Well, the ALJ found.
What they found is, I think in the record, what is it? What was it?
It was depression with suicidal ideation and anxiety features, and also attention deficit disorder. Those are the two severe impairments the ALJ found.
Yeah, but those are the results of the impairment. But what did he label as the type of depression she had?
I'm not sure if I understand your.
What's key is that the type of depression was endogenous depression, right? That's what the record says. That's undisputed. Endogenous. That's significant. You know what that means? What kind of depression it is?
No, Your Honor.
It's the depression that has no external triggers. Endogenous means that it's internal. It's very difficult to treat because exo, it means some other things like, for example, a death in your family, for example, or you have a situation, it could be drugs or something like that, or it could be romantic relationship, all those things are triggers or those things. And therapy tries to help you deal with those triggers. Well, next time someone does that to you, but for basically this kind of depression, it is almost sui generis. It's internal. It means you just start crying. You just, for no reason. In other words, if you notice in the record is that she had a very stable home and family. It's one of those things that you have every reason to be happy, but you're not because it's internal. And you don't have these triggers. If you get external, it's easy. Look, if you stop going around these people, if you stop doing that, That's important in this case. And you talk about the medication she was taking. That's the medication that's undisputed in this record was necessary to keep her going. And taking these drugs and this medication to treat yourself is the thing that makes it somewhat unable to deal with it, to concentrate in those things. So I don't see anything in the record that disputed Dr. Beal's conclusion that these things, they have no triggers. They just come and they last. And she's honest. I think she would be disingenuous. Say, no, every day I feel like I want to cry. No, but I don't know when it is that I do want to cry. That's the evidence. It's undisputed. And what you went down, well, I don't know about this. Maybe the days you don't cry, you could work. Or, as long as you're doing something that's not stressful. The only thing that the difference, no, go ahead. You're about to say something.
Well, Your Honor, I would point out the record shows that Ms. Cannon has been depressed since the age of 18.
Right.
She has a long history of psychiatric care. The ALJ acknowledges that. But this is also a person who successfully performed skilled, stressful work despite her depression for 10 years. And in the beginning of the argument, counsel suggested that she wasn't managing 100 employees. And I would just point out that the transcript at page 380, I took that from the transcript where she said Dr. Beal recorded that she was managing 100 employees. So the issue is not that she doesn't have depression. The ALJ certainly acknowledged that. And this is a person who was successfully employed for 10 years with the same impairment, performing skilled work.
But that's the problem, counsel. You punish people who persevere almost. She pushed through. It was 18, at 19 years old, she just sort of given up and just balling a knot and did nothing. Oh, that means she's not. She pressed through for 10 years. She's productive. She's doing things. But at some point, you get to the point where the body and the mind just can't endure. And you say, oh, you did it for 10 years. That means you certainly could do it another 10 years. It's contraindicated in terms of her diagnosis. And so we talk about the science, you just pick through that. The only thing that separates us from animals is our minds. And if your mind is something in the sense that in terms you can't control in terms of depression to the point where you get that it's just, I don't know. I think that's the question. I mean, Dr. Beal is deceased now, right? So he can't speak for himself. But he treated this lady since 2015, and it seemed to me that would go to her credibility in the sense that she did persevere and did these things. And but anyway, go ahead. I don't want to. You go ahead.
Well, one, as the court knows, the issue is whether the ALJ could have reached its fact finding, whether substantial evidence supports it. So the fact that a different fact finder would reach a contrary conclusion on the same record isn't what's at issue. It said, did the ALJ identify substantial, not high evidence to support his fact finding? And he discussed that Ms. Cannon, despite her complaints of never interdisability paperwork and hearing testimony that she never left her bed, that she cried all day, and that she was watching reruns only on a good day, she was telling her therapist that she was attending weekly art classes. She was able to push herself to do things as needed. She was attending weekly Weight Watchers. She was enjoying Christmas and with her family. She visited colleges with her daughter. She did light exercise several times a week. So there was a lot of conflicting evidence, and that's why the ALJ, as a reasonable fact finder in the case, articulated enough meaningful discussion to support why, as he, as a fact finder, found that Ms. Cannon could no longer perform skilled work, but based on the record before him, could perform a much more narrow range of simple work.
Where in the record did the hearing officer look at the fact that she underwent transcranial magnetic stimulation and how severe that is? That's one of the severest cases of depression. You don't get that in normal depression. That's a high level accepted that he consider that fact that she, right? Well, what weight is an evidence that he looked at that?
So the ALJ's discussion of the TMS treatment is on JA 17.
But you concluded that she was getting better from it. I'm talking the fact that she was, that was prescribed for her, that alone gives you the level of severity of her depression. You don't give transcranial magnetic stimulation to someone who has a base, no such thing as a normal depression, but a more of a continuum on the continuum of the spectrum. If you talk about a spectrum, that would be way on the far end spectrum of depression for that. What evidence was, what consideration really meaningful was given to that? And tell me, what did they say? Seemed like, did they do what you did? Say, oh, she had it. It seemed like she's getting better. What about the fact that it was prescribed for her and she underwent it? In fact, there's some evidence she was even considered for, I believe, electroshock therapy. That's something that we don't in a long time. It's been almost, well, anyway, it was a time when people, that was, lobotomies and electroshock and all those things. Fortunately, we've gotten through it. But that's the level of depression to even consider words like that, electroshock therapy and TMS. This is not your average depression case. You're treated like, well, some days she was okay. She could shop. She could take care. That's what you press on. We do a lot of times, as a parent and as a whatever, we do a lot of things that we could be in incredible grief and going through incredible emotions and grief, but yet you press through. But at some point, she sort of, but what is that evidence that are you saying that they just gave her TMS and this was a normal run-of-the-mill and that's fine and she's doing better?
No, Your Honor, I'm not suggesting that it was just a run-of-the-mill kind of treatment. But TMS is safe, effective, outpatient. It's something that was very, very effective. On page 509 to 511, Ms. Cannon that's where the summary of her TMS treatment records is. And she repeatedly told her providers that she was so happy she tried TMS. She was brighter, she was laughing, she was smiling more. And what's notable about the case is even though TMS was highly effective for Ms. Cannon, she elected not to do a second course because she was feeling okay. So that's a testament that she was doing fine with her medication management by Dr. Gill. She chose not to do so the ALJ wasn't dismissing the level of treatment or Ms. Cannon's subjective symptoms. What the ALJ was doing was reviewing the record as a whole and adequately accounting for the credibly established limitations by finding Ms. Cannon could only perform a very narrow range of simple work. And I see that my time is up. So if there are no further questions, we'll rest on it.
Thank you.
Thank you.
Thank you so much. Let's do. When do you have a few minutes left?
Thank you. I'd like to address just a few issues, and I think the questions from the court get right to the point here that of why it was so important to have the ALJ give an explanation, which he didn't give, regarding these factors, because there's lots of evidence here that calls his conclusions into question, and certainly the nature of the severity of the disease itself and the types of treatment that were provided, which are only provided to long-term, very severe cases, that militates in favor of requiring the ALJ to give a full articulation of all of the factors here, particularly when it's evident that the factors cut in favor of the claimant. The other point that I would like to make has to do with the activities of daily living and the evidence, which the commissioner has really cherry-picked out of this record, because the commissioner focuses on the evidence that shows that she did better here, or she had this activity, or so on, but ignores the fact that maybe a week later or 2 weeks later, Ms. Cannon is complaining about, well, I'm worse again. Or it didn't last. The treatment that I got, the TMS treatment, gave me no long-lasting benefit. And that's as we have argued in our opening brief, this is consistent with the nature of these types of mental illnesses. But with regard to the daily activities and whether Ms. Cannon was functioning well, and that is inconsistent with Dr. Beal's opinion, it's important to look to the agency policy and guidance on how to evaluate this. Some of it comes, and we did not cite this in the brief, but it comes out of the introduction to the mental illicit impairments under Appendix 2, under Section 12. And there's a very detailed discussion intended to educate adjudicators on how to look at this evidence. And in particular, it's important to look at how a claimant may appear to be functioning well, or at least moderately well, after leaving work. But in fact, the reason they appear to be doing well is because they're getting good psychosocial support. They're getting good treatment. The medication has been effective. It's keeping them from deteriorating to the point they have to go back into the hospital, which is the major goal in mental health now, deinstitutionalization, treating people in the community. That's the goal, which Dr. Beal stated was the goal for aggressive treatment, which she did receive. However, the guidance goes on to note that many of these patients will have a relapse if they're put back into a work environment. And so your environment at home, where you have psychosocial support, good medical treatment, and so on, is a factor that has to be considered. So in looking here, for example, about the daily activities, there's no evidence that Ms. Cannon was doing all of these activities that the commissioner has cited on a regular basis for a long period of time. In fact, it looks like she started some and stopped. But if you look at the records from the medical university and the counselor, it is consistently stated that she has good social support at home. And we obviously know she's gotten very extensive medical treatment. A lot of the activities were done with family members in a family context. Once again, the guidance under Section 12, subsection D and G speak to this issue and how this evidence should be considered. A lot of the activities had a therapeutic intent. For example, weight loss was a big issue, and that is a classic symptom of depression, according to the commissioner. Getting some physical activity, or finding some joy in some activity for a person who's down all the time. All these have therapeutic value. They were done under the direction of a therapist, and they were appropriate. They're not signs that she was able to go back into a work environment. I would also point to another guidance, which we did not mention, it did not cite in the brief, and it's in Social Security ruling 85-15. This ruling has to do with assessment of under the medical vocational guidelines, but it has a section which is often cited at the administrative level on stress and mental illness. And it also emphasizes this fact that even minor job-related stress can send a person with a serious mental illness over the edge. They might appear to be doing well within their safe environment with limited stressors, but put them back in the workforce, they go downhill. And that's a very important part of Dr. Beal's opinion. And yet, once again, the administrative law judge did not see fit. He may have considered it all, but he didn't see fit to explain it. And that is the heart of this case, is failure to follow these regulatory requirements to explain his reasoning. Unless there are other questions, I'll rest on my briefs. Thank you.
Thank you, Mr. Went and Ms. DiDomenico. Thank you so much for your arguments. We'd love to come down and greet you, but we cannot. But know very much that we appreciate your arguments in the case, and wish you well and be safe. With that, I ask the deputy clerk to adjourn the court for till tomorrow.
This honorable court stands adjourned until tomorrow morning. God save the United States and this